Human rights. So human rights is a very important concept under the international law. So how we got this term human rights? So basically human rights means all the rights which are for human. So if you are a human, you are entitled for all these rights. So these are not written in one day, but it is a work of many centuries. It started from 17th century. So in the 17th century and 18th century, there were revolutions and enlightenment going on in America and France, popularly known as American and French Revolution. And during those revolutions, people talked about their political and civil rights, that they should have a right to life and liberty, right to vote, right for fair trial, then freedom of religion, thought, conscience. So these things were discussed during these revolutions. So in the century 17th and 18th, we got the first generation, right, that is civil and political rights. So why these are called first generations? Because these are the first type of human rights that were ever discussed in the history of humankind. So the first generation rights are civil and political rights. I have also included this chart which in brief illustrates the second generation and third generation, but in the next slide I have explained them in brief. So for better understanding, first generation is civil and political right, second generation is economic, social and cultural rights, and third generation is the collective rights. So why we call them generations? Because they mark the period in which they have come. Like during 17th and 18th, we have got first generation rights, that is civil and political, and in second generation we have got it during the 19th and 20th century. So that is the second generation rights, economic, social and cultural. And after the 20th century, we have got the concept of collective rights, collective dimensions. What are the rights? That is for the collective people belonging to same nation or same community are getting those rights. So these are three types of generations under human rights that are mentioned under international law. And also there is discussion going on fourth generation. It will be related to digital protection and all. So it is still going on, the talk is still going on, but on papers, on theory, we are having only three generations of human rights: first, second and third. Second generation. So under this, there are three types of rights, that is dealing with economic, social and cultural. So this was developed during the 19th and 20th century. So we know we have witnessed two world wars during this particular time frame. So after the World War II, finally the nations came together and talked about development, commerce, economic benefits and progress. So this was the time when there was rise of socialism. Socialism means welfare for all. And also this was the time when the industrial revolution was at peak. It means that in many of the countries, industries were being established to promote their economic growth and stability. So because of this, the concept of economic, social and cultural rights came. So what are these type of rights? So examples are right to work in favorable conditions, right to education, right to participate in cultural life, right to physical and mental health, then right to adequate standard of living, food, clothing and housing. So these are some of the examples of economic, social and cultural rights. All these three rights are interrelated. If you are having economic right, then it is like that you will get social rights as well, and you will get cultural rights. So these three are interlinked and interconnected. Now comes the third generation. So these are also known as collective rights. So these emerged in the 20th century. Why these emerged in 20th century? Because we know in the 20th century the world saw the wave of independence, decolonization. Many of the countries were becoming independent from the colonial rule. So one of the example of collective right is the right to self determination. मतलब डिटरमाइन कर सकते हैं वहाँ के सिटीजन्स उनको किस कंट्री का पार्ट बनना है या नहीं बनना है, या सेपरेट आइडेंटिटी चाहिए. So this is one of the collective rights, right to self determination. Next क्या है? Right to development, that there should be right for individuals to participate and benefit from economic or political and social development. Third is right to a healthy environment. So environment is also a third generation right. Today we talk about environmental protection a lot. So this is a human right under the third generation collective rights. Next is right to peace, that every individual, every nation has a right, a human right to have a peaceful environment to live in. So these are some of the collective rights. So first generation rights are civil and political, second is economic, social and cultural, and third is the collective rights. For better understanding of three generations of human rights, I have inserted this graph in which it clearly explains the three generations, and also it has included the fourth one, which is still in development, and it is not official that there are four generations of human rights. So first generation, that is civil and political rights, it specifically talks about individual freedom and their right to participate in the political arena. Next is the second generation, it deals with equality in terms of social, cultural and economic rights. Third one is the solidarity human rights, also can be called as collective rights. And fourth one, if the fourth one gets developed, it will be dealing with digital technologies and biomedical rights. So these were the three generations of human rights under international law. So if a short note comes on this, then you can write about all three in details, and you can include the examples. It is not necessary to include only these examples which I have included. You can write other examples all as well, and you can also include certain examples so that it will make your answer more precise and it will fetch you more marks. Codification of international law. So first let's understand the meaning of codification. So codification is a process of having a systematic and formalized written laws relating to a particular subject. For example, in case of contract, in India we have Indian Contract Act. So if we want to look at the laws relating to contract, we know which legislation or which book to refer. But this is not the case of international law, because international law is not written in a same place. It means that there is no book only stating about international law. मतलब एक कोई legislation enactment नहीं है international law के नाम पर. The work is still going on. It has been going on since ages, the process to codify international law, but it is still going on, and the major part is played by the International Law Commission, ILC. So international law is not codified, it is not in a same place, or there is a book, but it has been scattered through various treaties, conventions, then decisions of the international courts, then international dispute resolutions. So these are some of the milestones or key points which has led to the development of international law without the actual codification. So if we want to refer to some convention dealing with sexual harassment, then we have CEDAW. CEDAW talks about all types of discrimination against women. So that convention is against the discrimination of women. So this is one of the example from where we have got rules or laws relating to sexual harassment of women or discrimination against women. Similar example can be from Hague Convention, which talks about the treatment of prisoners of war. Like if there has been a war and the victor country, how the victor country should treat the prisoners of another country which has lost the war, then rights and duties of such countries, the citizens, all these are given in the Hague Convention. So we have got such rules and laws relating to prisoners and wars from Hague Convention. So these are some of the examples. Now coming back to the slide, so the first line suggests that the codification of international law involves the systematic and comprehensive development and formalization of international legal norms and principles into legal written legal instrument. It means that codification should be in writing and it should be in a systematic format. Comprehensive होना चाहिए, systematic और formal होना चाहिए जिसमें written rules रहे. So currently international law is not codified. Why we need codification of international law? Because it helps in clarifying and making the laws more accessible and it will reduce the ambiguity. जितना भी vagueness है laws में वो कम होगा अगर written laws है तो. Today we know what are the contracts, what will result in breach of contract, because we are having a codified Indian Contract Act written है. So we know that okay, in case of this incident the punishment will be this. So in international law we do not have such thing, but the process to codify it is still going on, and the major role is being played by the conventions, treaties, customary laws, judicial principles, and it has been under the review by the International Law Commission, ILC. Now coming to the historical context. So the formal codification of international law began in the late 19th and 20th century. So it has been going on since ages, but still we have not got the codified international law. Now coming to the milestones, the major milestones. So first one is the Hague Convention, which was in 1899 and 1907. So two times Hague Conventions happened. These two are the years. So in Hague Convention we have got laws relating to wars and peaceful settlement of disputes. So international law is providing us principles and laws relating to wars and peaceful settlement through Hague Convention. So the Hague Convention guidelines or the recommendation that it has given, we consider it as a part of international law. Next is the Geneva Convention. So Geneva Convention talks about international humanitarian law. So Geneva Convention has paved the way or the foundation for international humanitarian law. और ये किस चीज से डील करता है? जितने भी कॉन्फ्लिक्ट्स होते हैं इंटरनेशनल लेवल पे, जो प्रिजनर्स होते हैं, सिविलियंस होते हैं, वुंडेड होते हैं, जो सरेंडर करते हैं, उनके साथ कैसे डील करना है, ये सारी चीजें जिनीवा कन्वेंशन में. और जिनीवा कन्वेंशन कब आया है? 1864 एंड 1949. और एडिशनल प्रोटोकॉल्स भी आया है. प्रोटोकॉल्स वो होते हैं जो कन्वेंशंस में बाद में ऐड किए जाते हैं, लाइक दे हैव इंक्लूडेड द प्रिजनर्स ऑफ वॉर एंड सिविलियंस, बट लेटर ऑन एक प्रोटोकॉल आ गया जो और भी चीज़ों को ऐड करा, जैसे व्हाट अबाउट द राइट्स एंड ड्यूटीज ऑफ पीपल हु हैव सरेंडर्ड. तो ऐसे प्रोटोकॉल्स होते हैं. प्रोटोकॉल्स को भी अलग से कंट्रीज रैटिफाई करती है, अलग से साइन करती है और बोलती है कि ओके नाउ वी विल फॉलो दिस. तो Hague Convention, Geneva Convention are two milestone in the development of international law. There are other milestones as well. So let's see the other slide. Next is the establishment of League of Nations, which was followed by the World War I to promote peace and security in the world. But we know that it failed miserably. And after that, we got United Nations after the World War II in 1947. Similar is the case with PCIJ, that is Permanent Court of International Justice. It was also established after the World War I, that is 1922. The main aim behind the establishment was to help in the codification of international law through judicial opinions and decisions. But later on, the role was taken by ICJ. So now we have इंटरनेशनल कोर्ट ऑफ जस्टिस एंड नॉट पीसीआईजे. पीसीआईजे और लीग ऑफ नेशन पुराना हो गया है. अब हम लोगों के पास यूनाइटेड नेशंस और आईसीजे है करंट कंटेम्पररी टाइम पर. सो द ICJ plays a very important role in providing judicial opinions and advisory in international matters. One interesting thing is that ICJ's decisions in cases do not become precedent. अब प्रेसिडेंट क्या होता है? मतलब अगर उस मैटर पर कोई डिसीजन आता है तो वही डिसीजन को रेफर करके आगे बढ़ाते हैं कोर्ट्स में. बट यहाँ पर आईसीजे के डिसीजंस प्रेसिडेंट नहीं बनते. दे बिकम एडवाइजरी ओपिनियन और सम गाइडलाइंस फॉर कंट्रीज. So ICJ plays a very important role in the codification of international law. And also the UN is having several organs, and those organs also plays a critical role in interpreting and applying international law, and these have helped in the development of international law, and these are also helping the International Law Commission ILC to codify the international law. तो एक जगह पे इंटरनेशनल लॉ नहीं है, बट through various means, through conventions, then through treaties, through different organizations, organs, through different judicial opinions, we have got the international law in place, but not in a particular legislation. International Law Commission. So we have been discussing about this a lot. So what is International Law Commission? So it was established by the UN General Assembly in 1947 with the aim to help in codifying the international law. Now what is General Assembly? So United Nations is an organization, international organization. So under that there are 5 organs of UN, and one of them is the General Assembly. Later on we will discuss about all the organs of the UN. So this General Assembly of United Nations established ILC with the aim of codifying the international law. So what is the function? Of course, it helps in the codification of international law, along with helping with the drafting of conventions, articles and guidelines of various treaties and conventions. And it has also established customary international law which were needed for the formal legal framework. Now the major contributions of ILC till date. So the first contribution was the draft articles of Law of Treaties, which is also known as Vienna Convention 1969. So it has helped in its creation, interpretation and termination. So ये सारे clause को draft करने में ILC का बहुत major role था. किस चीज में? Law of Treaties, जिसको हम लोग Vienna Convention भी बोलते हैं. Next is it has drafted articles on state responsibility, which reflected customary international law. So the ILC took the help or reference from customary international law and drafted the articles on state responsibility. मतलब state की क्या responsibility बनती है ये सारे circumstances में. There is your fourth unit on state responsibility. So we will be covering about state responsibility in fourth unit in detail. Next is your draft articles on the responsibility of international organization. So in 2011, ILC drafted articles stating that international organizations also have responsibility under international law. So these are some of the major contributions by the ILC, and one of the major goals of ILC is to कोडिफाई द इंटरनेशनल लॉ. क्यों चाहिए कोडिफिकेशन? एक जगह पे इंटरनेशनल लॉ क्यों चाहिए? बिकॉज इट विल हेल्प विद स्टेबिलिटी, प्रिडिक्टेबिलिटी एंड ऑल्सो इट विल बी मोर क्लियर कि इस सिचुएशन में कौन से लॉज अप्लाई होंगे, और अगर ऐसा सिचुएशन में कोई आता है तो कौन सा पनिशमेंट होगा, किस कोर्ट में ट्रायल होगा. सो ऑल दीज विल बी much easier if it has been codified. So I've inserted this picture of International Law Commission. So this is how they draft articles on conventions, guidelines. So there are 34 expert members which are elected after every 5 years. So there is this rotation going on. और कौन elect करता है? United Nations General Assembly. तो किस basis पे elect होते हैं? उनके qualification, expertise के basis पे. So that they can help in formalizing international law or codifying international law. So this is the picture from ILC. Sanctions of international law. So the sanction under international law means measures, penalties or punishment which is imposed or given by some international organization and international courts to individual states or international organizations if they are not following international law, or if their action is affecting some of the laws which are mentioned under international law. So what was the need of sanction? We know that if there is no punishment or no penalties given, then the chances are very high that international law will not be taken seriously. So the aim was to maintain peace and security of the world, to uphold human rights and also to ensure the compliance of international law. So this is the reason why we have sanctions, punishments and measures or penalties under international law. So there are different organizations and courts which has different sanctions rights. So first we are starting with United Nations Security Council. Before this, there are four types of sanctions. First is political, economic, diplomatic, or military. So these are some of the type of sanctions which are mentioned under international law, and we will discuss about these four in under various headings. So first, starting with the United Nations Security Council. Now what is Security Council? It is the organ of United Nations. मतलब यूनाइटेड नेशंस के अंडर में 5 ऑर्गन्स आते हैं, उसमें से एक सिक्योरिटी काउंसिल है. एज द नेम सजेस्ट, द रोल ऑफ सिक्योरिटी काउंसिल इज टू मेंटेन इंटरनेशनल पीस एंड सिक्योरिटी. So for maintaining that, the power of United Nations Security Council is to impose economic sanctions, arm embargoes, travel bans, or asset freezing. So these are some of the sanctions that are available with the Security Council. So let's understand this with live examples. So in case of economic sanctions, it has been imposed by UNSC on North Korea and also on Iran. क्यों impose हुआ था? Because they were not complying with international laws. So the United Nations said that all the members of United Nations shall not do economic trading with North Korea and Iran. Why? Because they are not complying with international law, and because economic sanctions are being imposed, so their access in North Korea's and Iran's access to international financial system and trade will be restricted, will be controlled, and that will eventually affect their economic well-being of the country. नेक्स्ट इज आर्म्स एम्बार्गोज. एम्बार्गोज का सिंपल मीनिंग होता है ब्लॉक करना या रेस्ट्रिक्ट करना. तो ये अप्लाई हुआ था लीबिया में, जब लीबिया में वॉर चल रहा था. सो व्हाट हैपेंड, यूएनएससी टू प्रिवेंट दैट वॉर और टू मिनिमाइज द कैजुअलिटीज, दे रेस्ट्रिक्टेड द इनफ्लो ऑफ वेपन्स. जितने भी नियर बाई एरिया से वेपन सप्लाई हो रहे थे लीबिया को, या फिर जो कंट्री सप्लाई करी थी, उसको रेस्ट्रिक्ट किया गया. दैट वी आर इम्पोजिंग आर्म्स एम्बार्गोज ऑन लीबिया so that there should be shortage of weapon and war can stop. Next is travel bans and asset freezing. So this is basically this basically targets individuals and international organizations. क्यों उनको टारगेट करते हैं? अगर उनकी कोई एक्टिविटीज़ होती है जिससे इंटरनेशनल पीस एंड सिक्योरिटी को थ्रेट हो, जैसे टेररिस्ट को फाइनेंस करना, टेररिज्म फंडिंग बोलते हैं, अगर वो करते हैं तो उनके ऊपर ट्रैवल बैन्स भी लगता है. मतलब आप ट्रैवल नहीं कर सकते ये पर्टिकुलर कंट्रीज में, और उनके एसेट्स को भी फ्रीज किया जा सकता है. सो दीज आर सम ऑफ द पावर्स ऑफ यूएनएससी अंडर सैंक्शंस ऑफ इंटरनेशनल लॉ. Sanctions under international law can also be imposed by United Nations General Assembly. अब जनरल असेंबली क्या होता है? तो जनरल असेंबली भी एक ऑर्गन है यूनाइटेड नेशंस का, जैसे सिक्योरिटी काउंसिल है, बट दिस इज ऑफ मोर एडमिनिस्ट्रेटिव नेचर. मतलब यहाँ पे पॉलिसीज डिस्कस होते हैं बाय डिफरेंट मेंबर्स ऑफ यूनाइटेड नेशंस. डिफरेंट कंट्रीज आके मेंशन करती है, फिर वो लोग डिफरेंट रिकमेंडेशन या रेजोल्यूशन अडॉप्ट करते हैं दैट वी शुड डू दिस एंड वी शुड डू दैट. So these resolutions and recommendations are not legally binding, but General Assembly can urge their members to take collective actions or impose collective sanctions on certain states or international organization. तो यहाँ पर क्या है, लीगली बाइंडिंग नहीं है क्योंकि एक एडमिनिस्ट्रेटिव ऑर्गन है, बट रिक्वेस्ट कर सकता है या प्रॉपर प्रपोज कर सकता है दैट वी शुड डू दिस, एंड इफ द कंट्रीज अग्री देन देयर शुड बी अ कलेक्टिव एक्शन. So one of the good example is the apartheid sanction. So apartheid एक regime आया था साउथ अफ्रीका में, जहाँ पे जो all white government था, they imposed this plan that all the whites will live in separate area and all blacks will live in separate area. So this was a very racial discrimination regime which was happening in South Africa. So UNGA imposed a sanction against this regime, and UNGA played a very critical role in mobilizing international against this regime. So this is a very influential contribution by the UNGA in terms of sanctions under international law. Next comes the International Court of Justice. This is another organ of United Nations. So this Court of Justice is at international level, and all the cases relating to states and organizations are referred or discussed at International Court of Justice. So what happens? the ICJ gives advisory opinion on legal questions अगर different states refer करते हैं या UN body refer करता है that this is the problem, what should be there, so ये court बैठकर advisory opinion देता है. And also it gives judgment, but ICJ का judgment president नहीं बन सकता, we know that. And also ICJ cannot directly impose sanctions. It can give advisory opinion, it can give its judgment, but cannot enforce or impose sanctions directly. तो इस केस में क्या होता है कि अगर आईसीजे के जजमेंट को कंप्लाई नहीं करते हैं, स्टेट नहीं मानते या नहीं फॉलो करते हैं, तो जो मैटर है वो यूनाइटेड नेशंस के सिक्योरिटी काउंसिल में भी जा सकता है. फिर यूनाइटेड नेशन सिक्योरिटी काउंसिल थ्रू इट्स वेरियस मेजर्स, जैसे हम लोग अभी पढ़े थे, इकोनॉमिक सैंक्शंस, ट्रैवल बैन्स, एसेट फ्रीजिंग, आर्म्स एम्बार्गोज, उसके थ्रू सैंक्शंस इम्पोज कर सकती है उस कंट्री या फिर इंटरनेशनल ऑर्गेनाइजेशन के थ्रू. Similarly, like ICJ, ICC also imposes sanction, but it imposes on individuals. ICJ imposes on states and international organization, and ICC imposes on individuals. So ICC prosecutes or tries individuals for the most heinous or serious offenses that are under the international law, which is genocide, war crimes, and crime against humanities. So these are some of the areas where the ICC deals with. So ICC can issue arrest warrant, and the member states of the ICC are obligated to arrest and surrender such individuals to the ICC. अब surrender होने के बाद ICC में case चलेगा, evidences, hearing, arguments will go on, and then the judgment will be delivered. ऐसा एक example है एक military leader के against which who committed international crimes, and arrest warrant was issued against the Sudanese president Omar al-Bashir. So the arrest warrant was issued and he was arrested. Next is the permanent court of arbitration, इसको PCA भी बोलते हैं. तो रोल क्या है इसका, इंटरनेशनल लेवल के सारे जो डिस्प्यूट्स होते हैं बिटवीन स्टेट, प्राइवेट पार्टीज या इंटर गवर्नमेंटल ऑर्गेनाइजेशंस, उनको रिजॉल्व करवाना थ्रू आर्बिट्रेशन. सो इट इज एन आर्बिट्रेशन बट एट इंटरनेशनल लेवल. So the PCA does not impose sanctions but award देता है. और अवार्ड मोस्टली किस टर्म में होता है, रेमेडीज के फॉर्म में, लाइक फाइनेंशियल कॉम्पनसेशन या फिर कोई भी अदर रेमेडीज के फॉर्म में. अब इसका एक और एग्जांपल है इन्वेस्टमेंट डिस्प्यूट. तो जो PCA है वो इन्वेस्टमेंट रिलेटेड चीज़ें भी हैंडल करता है. तो अगर कोई स्टेट इन्वॉल्व है या फिर कोई गवर्नमेंट या प्राइवेट पार्टीज इन्वॉल्व है किसी इंटरनेशनल इन्वेस्टमेंट अग्रीमेंट के ब्रीचेस में, देन ऑल्सो द मैटर कैन बी डिस्कस्ड एट PCA, एंड PCA कैन नॉट इम्पोज सैंक्शंस डायरेक्टली बट कैन गिव आर्बिट्रल अवार्ड इन फेवर ऑफ द विनिंग पार्टी, और फिर वो अवार्ड को फॉलो किया जाता है. एंड मोस्टली अवार्ड कॉम्पनसेशन के फॉर्म में होता है. So these are some of the organs or organizations which can impose sanctions under international law. Subjects of international law. So the meaning is on which particular subject matters or subject the international law can be applied. तो इसका division है दो में. So first is states and second is non-states. So under states we know that countries, we call countries as states. So different countries are a subject of international law. जितने भी different countries से related dispute होंगे at international level, international law will be applied. And next is the non-state actors. So under this is international organization like United Nations, WTO, Security Council, General Assembly, ITLAS, ICJ, ICC, all will fall under international laws subject. And second one is a legal standing of individuals, meaning individuals, private individuals. This particular branch is dealt under private international law, जो सिर्फ individuals पर होता है, and under public international law, states and international organizations are dealt. But overall, the subjects are divided into two parts, that it's states and second is non-states. State is the countries and non-states are the international organizations and individuals. And also in many cases, multinational corporations are also included. So to understand this better, we have this chart. Under states, we are having the names like Malaysia, UK, USA, China. And in the non-states, we have individuals, international organizations and multinational corporations. So These are the subjects of international law. Reparation for injuries suffered in the service of the United Nations case. So this case was referred to ICJ for advisory opinion. So what happened in the year 1948, एक UN mediator थे पैलेस्टाइन में, जो जिनका नाम था काउंट फोग बर्नाडोट, and he was assassinated in Jerusalem while he was performing his duty on behalf of United Nations. So he was there to mediate between Israel and Palestine, and then during the duty he was assassinated. So the UN General Assembly requested ICJ for the advisory opinion that what we should do. Our member and our agent has been assassinated while he was on his duty. So to prevent this, what steps should we take? And can we bring the claim of reparation against the state? Reparation का मतलब होता है amends करवाना या compensation. So these were the legal questions which were raised in the ICJ, and UNGA asked for the advisory opinion कि क्या advice होना चाहिए और क्या extent होना चाहिए compensation का या reparation का against the state. So ICJ found that and highlighted that United Nations has a legal personality. मतलब the United Nations can file a case in the court, can present itself as a legal entity. So the United Nations can bring a claim of reparation against the state. So this was the finding of the ICJ in this case. So let's see what happens next and what was the judgment in this case. Next, the ICJ gave the opinion that the UN has the right to claim for reparation. What is reparation? Against for the to make amends or the damages that should be given by the state for assassinating the agent of the United Nations while he was performing his duty. And next, the scope of reparation. ICJ also talked about it and said it should be enough or adequate to compensate for the loss or damage that has been suffered. Like the person has been killed on his duty, so it should be compensatory enough. And this includes material and moral damages such as loss of life, physical harm, and any hindrance to the UN's functions. So through this case, the major things got highlighted, like the United Nations is a legal personality. That means it can approach the court, it can bring the claim in the court. Also the right of reparation, the United Nations has the right to claim for compensation, and also the scope of compensation, reparation, it should be adequate enough so it covers the moral damage, physical damage, or any loss of life. So these are some of the significance that were highlighted in this case. So this case is important from the perspective of the international law. Ukraine versus Russian Federation. So this is the name of the case, and it was filed in 2019 in the ICJ for the advisory opinion. So what happened? Ukraine filed a case against Russia on two grounds: that it has violated two of the international convention. First is relating to financing of terrorism, and second is of racial discrimination. So Ukraine claimed that Russia is responsible for supplying armed supports to the rebellions in the eastern Ukraine, and also Russia is denying the cultural, educational, and political rights to ethnic Ukrainians in the region. So these were the two claims that the Ukraine raised against Russia. So the matter came to ICJ, and ICJ decided that due to lack of evidence, the Ukraine was not able to prove the armed support or financing of terrorism. But later in March 2022, when Russia invaded Ukraine, the court realized that there were sufficient evidence to support the claim of Ukraine, and it asked Russia to immediately prevent all the actions of funding terrorism. And also the ICJ gave opinion or judgment and asked the Russia to stop the racial discrimination against the Ukrainian. which is violative of both the convention. First is suppression of the financing of terrorism convention, and second is elimination of all forms of racial discrimination. So this is the case of Ukraine versus Russian Federation, which was filed in ICJ in 2019, but the judgment came after 3 years, that is in 2022. So this case is also known as the application of the International Convention for the Suppression of the Financing of Terrorism and of the International Convention on the Elimination of all forms of racial discrimination. So two things were discussed. First is funding of terrorism, and second is racial discrimination. And this case was against Russian Federation, filed by the Ukraine, and the opinion was given by the ICJ, and the final judgment came in 2022. So I have briefly explained about the case, and these are some of the points which I have included. So what were the ICJ's provisional measures, then what were the claims in terms of financing terrorism, and also in terms of racial discrimination. So these are some of the cases, the two particular cases which are very important from the international law perspective. So try to understand it in a story format, and you will not forget it, and it will become very much easier for you to write in the examination, and also it will help you in fetching more marks, because inserting these cases will make your answers more authentic and more good. Third world and international law. So in today's time, third world countries are the developing countries in Africa, Asia and Latin America, and this term was coined during the Cold War period. So Cold War period was after the World War II, when there was no actual fighting or actual wars going on between the states, but there was this Cold War that it may happen. So what the countries were doing, they were joining different alliances, और वैसे दो alliances हैं, NATO and Communist Bloc. अभी के टाइम पे Communist Bloc नहीं exist करता है, but NATO still exist. तो नेटो में मोस्टली यूरोपियन एंड अमेरिकन कंट्रीज ज्वाइन किए थे, एंड इन कम्युनिस्ट ब्लॉक मोस्टली दी सेंट्रल यूरोपियन कंट्रीज, African, Latin American and Asian countries joined. But there were other countries as well which did not join any of the bloc. इसका सबसे अच्छा एग्जाम्पल है इंडिया. इंडिया सपोर्टेड दी नॉन अलाइनमेंट मूवमेंट, नाम बोलते हैं इसको, and India said that we are not going to join any alliance and we want to focus on our economic growth, and we are not concerned anymore about the world wars, because India was never a part of the world war. So NATO still exists and communist bloc has been disbanded. अब communist bloc क्यों नहीं है, क्योंकि बहुत सारे internal protests and civil wars हुए थे. That is the reason communist bloc do not exist in today's time. And NATO is one of the reasons why Russia invaded Ukraine. So Russia warned Ukraine many times that if you join NATO, we are going to invade you. But Ukraine wanted to join NATO and was very persistent about it. So as a result, Russia invaded Ukraine. And why Ukraine wanted so badly to join NATO? Because in such alliances, it is an obligation on all the members of NATO that if any country attacks any member state, then it will be considered as the attack on all of them. मतलब अगर एक भी कंट्री में जो नेटो का मेंबर है उस पर अटैक होता है, तो सारे मिलकर एक्शन लेंगे अगेंस्ट दैट कंट्री, एंड दिस इज व्हाट रशिया डिडंट वांटेड फ्रॉम यूके. So it want, and but Ukraine wanted to join the NATO, so the invasion happens and the war is still going on. So now coming back to third world and international law. So in simple words, we can say Africa, Asia and Latin America can be called as third world countries. So the relationship between third world and international law is complex because of colonial history, economic disparity and struggles for political and social justice. So the colonial legacy, if we talk about, so many third world countries were colonized by European powers, British powers and American powers, and we know that the international law has been very much shaped by these powers. So there has been hesitation among the third world countries regarding the compliance of international law. So if we come to the decolonization part, so the mid 20th century saw the wave of decolonization. Many of the countries became independent from these powers, European, Britishers and American powers, and they wanted to have an independent and sovereign nation. So they sought to international law, and international law also have concepts like self-determination, sovereignty over their territories. So international law is trying to favor third world countries, but again the relationship is little bit complex. So there has been a scholarly movement called as Third World Approaches to International Law, TWAIL. So this is a theoretical framework which critically examines the international law from the perspective of the third world countries. What these countries think about some of the international laws and international law as a whole. So the TWAIL has often argued that the international law has been Eurocentric, मतलब यूरोप के point of view से है, and it has been made to benefit them, and it has advocated or promoted inequality and domination. और इसके कुछ स्कॉलर्स हैं जिनका कहना है there should be reform in international law so that there should be justice, equality and development for third world countries. And because of this TWAIL, there has been many changes and many treaties that have been signed that supports the development of third world countries, and not only on already developed countries like America, European countries. So TWAIL has played its role in helping the third world countries in relation to the international law. So this particular map shows the third world countries, though. So the countries highlighted with green are the third world countries, and rest of them are another thing like the countries which have joined NATO or the developed countries. So this TWAIL is particularly for the countries which are highlighted in green. That was all in your unit 1. So from your exam perspective, a question may comes to explain about discuss the nature, scope and development of international law, or a question may come, a short note may come on generations of human rights, or a question may comes on sanctions under international law, a question may comes on subjects of international law. So while discussing all this, try to include the two cases which I have discussed. It will help you get better marks, and it will also impress the examiner while checking your paper. And also the third world and international law part, so it might not come directly in your exam, but if it comes, it can come in the short note. And if while writing the long answer you are thinking that no, the length is not very good, I need to write more and make it lengthy, so you can include this part also, third world countries and international law. It can be included under any heading in the first unit's question. So all the best for the first unit.